Welcome all of you to this panel presentation. As Dee Dee said, this was planned by Nancy Weber, who's chair of our Justice Committee, and myself, chair of our Health Committee, to address two related but distinct mental health and justice issues. First is a Marin-specific matter involving permission for jail personnel to administer psychiatric medications to severely mentally ill inmates. Involuntary administration of psychiatric medication was approved by our Marin Board of Supervisors in August, as requested by Marin Behavioral Health and Recovery Services, and is aimed at reducing major behavioral disruptions and individual harms to self or others in the jail. Second is a controversial statewide matter requiring all counties to institute new care courts with powers to address treatment of severely mentally ill persons, requiring actions by a wide array of local public services at unknown but major costs to the county and to the state. So far, the state spent $88 million on this in this year's budget alone. The new care court legislation, originally proposed by Governor Newsom, SB 1338, was approved by the legislature and then signed into law this September. We are honored that these key department leaders, who I will introduce, have agreed to come talk to us about how Marin is planning to roll out these new programs, what the concerned departments hope for, doubt, expect, and how for care courts we locally or as a state hope to supply the required housing, mental health professionals, institutional beds, representation by public defenders, public guardian, all already overburdened. So this is a huge project impacting a wide range of county programs, but we can only choose a few select leaders for this panel. And so we are delighted to have Todd Schirmer, Director of Behavioral Health and Recovery Services, Jamie Scardinia, Sheriff, David Joseph Sutton, our Marin Public Defender, and Mark Vanderscoff, our Marin Public Guardian. So who don't we have on the panel? Well, no representatives yet from our superior civil court system, from housing and homelessness, first responders, family members, advocacy organizations, and so on. This meeting is really just a start. We plan to have at least one or more follow-up meetings to hear from these other people, and we'll also be following progress in other counties. So with that, I'm going to turn this to Todd Schirmer, our County Director of Behavioral Health and Recovery Services, and he has very generously agreed to give a basic overview of what the care court legislation entails and then how behavioral health is preparing. So over to you, Todd.
Great. Thank you, Doug. Appreciate the introduction, and it is an honor to be here today on this panel. Like Doug said, I am Director of Behavioral Health and Recovery Services. So just as a bit of context, so Behavioral Health and Recovery Services is the county's public behavioral health entity. So we provide substance use and mental health services to people who have serious mental illnesses and serious substance use disorders who have Medi-Cal and are low income. We also provide a continuum of crisis services to all Marin County residents who are in need of that level of care. And we engage in a variety of prevention and early intervention activities designed to reduce the impact of mental health and substance use disorders. Examples of those would be our Suicide Prevention Collaborative and OD-Free Marin. I've been in this job for just a short period of time. I was appointed after our previous director resigned in August. So I am here now to kind of go over some of these topics that Doug introduced. And I think before getting into some of the details about some of the involuntary behavioral health treatments that we're going to be talking about today, I do just want to offer a quick caveat that Behavioral Health and Recovery Services believes very strongly in voluntary treatment. We respect client choice and client rights, and it is our goal, our mission to engage clients and have them receive services voluntarily whenever possible. The law does allow for certain situations where involuntary behavioral health treatment is necessary. That's usually to preserve life and safety. So for example, if somebody is a danger to themselves, a danger to others, or if they have challenges meeting their basic needs due to a severe mental illness, then there are involuntary treatment options. Typically, we would think of our crisis stabilization unit as a location for those types of services or our mobile crisis response team. Today, we're here to talk about two new processes that relate to involuntary treatment. So I'm going to share my screen now. Okay. All right, so as Doug mentioned, Senate Bill 1338 was passed into law just this past September. The governor's goal here was to create a new framework to help people exit homelessness and enter treatment in a community-based setting. This is very much pitched as a solution to the ongoing homelessness challenges we do face in this state. The CARE Act is focused on people who have a schizophrenia spectrum or other psychotic disorder. They have to have, they are unlikely to survive safely in the community without supervision. Their condition may be deteriorating, or the person needs supervision and services to prevent a relapse or deterioration. These are folks who are not participating in voluntary treatment, but yet they don't meet criteria for an LPS conservatorship. And I think Mark will speak a little bit more about the nature of LPS conservatorships in a little while. The CARE Act creates a new CARE court framework, and that framework is for up to 12 months with civil court oversight of people who are in this program, with the possibility of an additional 12 months. And I saw it went in the chat, so Marin County is actually in cohort 2, meaning we'll have a program launched by December 1st, 2024, so just about 2 years away. Referrals from CARE Court can come from a variety of people. That can be care providers, family members, first responders, government agencies. CARE Court does create some sort of legal protections through a legal support fund, which will likely be overseen by legal aid. And then there is a supporter role, which is somebody who can help a person who's in CARE Court make decisions and understand what's happening to them. If at any point a person in CARE Court is unsuccessful, then they will be referred for an LPS conservatorship investigation. If the county is non-compliant with CARE Court, with the foundations of CARE Court, then there is a possibility of a $1,000 a day fine for the county per client. As part of CARE Court, the county will be required to create a care plan for each individual, and that will involve some sort of community-based behavioral health services, psychiatric medications, housing, and public benefits. We have run some preliminary numbers, and we think that anywhere between 200 and 500 people in Marin County might be eligible for CARE Court, although we don't think all those people would ultimately filter into the program. And so we're projecting currently a program of about 80 people at any given time in a CARE Court program. And just as a frame of reference, Marin County currently has 4 other collaborative court programs, including STAR Mental Health Court, Adult Drug Court, Diversion, and Veterans Court. And the total census in all 4 of those programs is 80 people, about 80 people. So we're looking to be to about double the size of our collaborative court process. So CARE Court will not be without the need for resources. There's quite a lot of resources coming that we will need to identify and figure out how to fund. There is an extensive eligibility process that involves an initial investigation of a petition, a clinical evaluation. So those will be likely behavioral health professionals within behavioral health and recovery services. There is the need to develop a care plan, and that will be behavioral health and recovery services staff working with the legal defense and that supporter. And then there's a variety of eligibility and status review hearings in the Superior Court about every 60 days. So as you can see already, there's quite a lot. This is a resource intensive process, and that's just to get somebody into the program. Once somebody is found eligible for CARE Court, they will need to be enrolled most likely in a full service partnership level of care. That is our highest level of care in behavioral health and recovery services. That includes wraparound psychiatry, case management, mental health, and other substance use treatment. And then there is going to be a need for a comprehensive housing continuum, including both emergency and transitional housing, but then ultimately permanent supportive housing. And there is always a chance that inpatient treatment might be needed for clients who are in CARE Court. And then as Mark will speak to later, if somebody is not successful, then there will be a need for conservatorship investigation and ongoing court hearings related to that. So one of the major questions with Care Court is the funding that we could expect to leverage or have direct access to. The state has identified over $5 billion in growth in behavioral health funding in the last several years. And that's in Medi-Cal billing, Mental Health Services Act funding, and realignment. Not all of that funding is necessarily directly applicable here, but the state is highlighting that funding growth. The state is also pointing out there's $14 billion in new housing and homelessness focused funding. For example, the Behavioral Health Community Infrastructure Project has quite a lot of money behind it. And so the state is expecting us to leverage that funding. Now, however, as Doug did mention, Care Court itself has only at this point been allocated $88 million statewide. And that's largely for planning and infrastructure purposes. And just as a point of context, Marin County did receive our first implementation payment, and it was $250,000. So we are going to have to look at multiple other funding sources to have a robust Care Court program. Okay, so that's a very quick overview of Care Court. And I'm going to pivot now to involuntary medications in the county jail. So briefly, Marin County has a mental health team in the county jail. It is staffed by mental health professionals 20 hours a day, 7 days a week. We have a psychiatrist on site 20 hours a week, and we have on-call psychiatry coverage 24/7. People who are in jail receive screening and then mental health evaluation if they have a serious mental illness. And people who do need psychiatric medications are offered these medications. To this point, those medications have been voluntary, so people do have the right to refuse. In certain situations, primarily people who are incompetent to stand trial, so that means they have been charged with a crime, but they are unable to understand their crime, they're unable to understand the legal system, or they're unable to work rationally with their attorney. If people are incompetent to stand trial, especially on a felony charge, the court often issues an involuntary medication order. The court's point of view is that restoration to competency is in the best interest of the person and the criminal justice system, and so they issue those involuntary medication orders. Up until August of this year, even if somebody had an involuntary medication order, we were not able to medicate them involuntarily. Looking at sort of the landscape of involuntary treatment in the county jail, Marin is the only county in the Bay Area that had no options for involuntary medications. Other counties had a county hospital where incarcerated people could go and get medicated. Some counties had an in-custody psychiatric facility, meaning a hospital within the walls of the jail. And then several other counties are doing the protocol that we are now piloting here in Marin County, which is to do involuntary medications with mental health staff in the jail. So our rationale for this is that people who have untreated psychosis or mood disorders within the jail often have very serious symptoms. People are given opportunities to take medications voluntarily, and as I mentioned before, that is always our preference. But in some cases, their mental illness is such that they don't recognize the severity of their symptoms and they decline medications. These individuals are clearly suffering. They can be difficult to manage by custody staff. They may engage in violence or self-injury. And for those who are waiting for beds in a state hospital because they're incompetent to stand trial, they may
tell me what it is.
Very extended.
Okay, let me pull it up there.
Furthermore, if those folks were not in jail, they would likely be eligible for involuntary medications, either through an inpatient psychiatric hospitalization or a conservatorship. And just two other contextual factors is that Marin County received designation as an innovator county under the Stepping Up initiative in 2021. And so appropriate treatment of incarcerated people is in line with the goals of the Stepping Up initiative. And then lastly, the grand jury has periodically reviewed services in the jail. And following the termination of a contract with Santa Clara County, goodness, probably 6 or 7 years ago at this point, the grand jury did recommend that we explore procedures for involuntary medications for incarcerated people. So it's our goal through this protocol that we can provide compassionate treatment for people who are incarcerated, and this treatment will match the community standard. We're hoping for a calmer and safer jail environment, as well as a reduction in length of stay, reduction in the revolving door for people who go to the Department of State hospitals and then come back to the county. We have begun piloting these procedures, and thus far they have happened safely and without significant adverse incident. Okay, I'm going to stop sharing now.
Thank you very much, Todd. So I'm going to bring on Nancy Weber now, and she'll introduce our next speaker.
Hi, before I introduce the next speaker, I would like to remind everyone if they have any questions, please put them in the chat box. And if you'd like to ask your own question, just put in some question marks in the chat box and I'll call you at the end of the program. So now I'd like to welcome Sheriff Jamie Scardinia. He's literally the new sheriff in town. Sheriff Scardinia is a 23-year veteran of the Sheriff's Office and was elected in June. So he was sworn in as sheriff in July, becoming Marin's third sheriff since 1983. Thank you, Sheriff Scardinia, for joining us today.
Great, thank you for having me. And not only that, to just explain a little bit about why we're going in this direction of involuntary medications and what it means. And I'm sure there's going to be lots of follow-up questions after this. I don't have a PowerPoint presentation. I think a little bit about what I'm going to say is maybe might be a little bit of an echo of what Todd Schirmer just talked about. But what I want to portray today is that this has been a partnership between the Sheriff's Office and Health and Human Services. As Todd mentioned, HHS does provide medical and mental health services in our jail, and that's been a very good partnership, and we've worked well together for many years. So why now is maybe the question you're asking. Why involuntary medications now? Well, as Todd mentioned, the 2017 grand jury report was a big indicator for that, and also a change in leadership at the Sheriff's Office. For me personally, and for the Sheriff's Office, I felt this was the right time to start involuntary medications in the jail. As somebody who was the jail commander for 2 years, worked my way through working in the custody facility as a deputy, a sergeant, and a lieutenant, I saw the conditions that unfortunately some of our incarcerated individuals were living in. And as Todd mentioned, we are always going to try for voluntary medication. One thing, many things we will not do. We will not use involuntary medication as a form of discipline. This will be a planned event. This will not be, an incident that has happened in the Marin County Jail, and all of a sudden we're going to force medication on an individual. That absolutely will not happen. This will be a planned event, a coordinated event with Health and Human Services and with medical and psych staff and the deputies who work at our jail. And it's also important to know that the deputies absolutely will not be the ones administering this medication. We will be there to ensure that everybody's safety during this process. We did visit several facilities prior to coming to this decision. We visited Sonoma County. We visited Santa Clara. We talked with staff. We talked about the pros and cons of involuntary medications. And the common theme in all of those conversations were the staff, whether it be the deputies, whether it be the medical or mental health professionals in those facilities, were overwhelmingly in favor of the involuntary medications. What we see oftentimes from individuals who are deemed incompetent to stand trial, they wait many, many, many months to get to a state hospital bed, whether that be sometimes 3 months or 6 months for a bed to become available. And what we were seeing just in our own facility is the deterioration behavior in these individuals, whether they're just not following orders, they're just not listening, they're not bathing, they're not eating. As Todd mentioned, there's the self-injury. And I know not a very pleasant visual, but oftentimes some individuals are in their own feces. And it's just deplorable conditions that nobody should have to should be in. So those are some of the factors that we took into consideration when working with Health and Human Services and deeming the jail to be a treatment facility and bring this program before the Board of Supervisors just a couple months ago. So that's all I have right now as for an opening, and looking forward to answering any questions.
Thank you, Jamie. Now I'd like to introduce Public Defender David Joseph Sutton. He is also a longtime veteran of the Public Defender's Office. David began his career as a summer intern in 2006 and was appointed as the Marin County Public Defender in September 2021. Thank you for joining us today.
Thank
David?
you for having me. And it's an honor to be here. And I guess first I'll tackle the care court issue and then talk about involuntary medical orders and how the Public Defender's Office is involved. Initially, the first drafts of Senate Bill 1338 contemplated public defender involvement from the outset, meaning we would represent the patients or the respondents. However, as a result of cost modeling to the larger counties, say Los Angeles, San Francisco, even San Bernardino, et cetera, public defenders were kind of the second choice in the final version of the bill. Currently, if an individual is referred to care court, that respondent or that client, in the first instance, assuming that a legal aid organization has opted to take over and staff that court, a legal aid individual, or excuse me, attorney from legal aid would represent clients within care court. Text of the actual bill indicates that where a legal aid service provider is not available in the county, those clients will then be referred to public defender offices. Care court creates, I'd say, three real major concerns for the public defender's office. First and foremost, our mission is to provide high quality, zealous legal advocacy for our clients, each and every single one of our clients. And that would include care court individuals referred to care court. And as Todd indicated, the likelihood that 80 individuals would be referred to care court, or basically double the total number of our collaborative courts, that is going to be a large groundswell of new clients. Which means, in order to provide that high quality, zealous legal advocacy, we'd be looking at least funding 2, if not 3 attorneys, as well as either a recovery coach or some sort of social worker to adequately and competently staff these courts, and not just staffing the courts, right? That's not really our concern. Our concern isn't staffing the courts and having a body there. It's having an advocate for a respondent, having an advocate for an individual who's suffering from a pretty significant mental health issue, and really making sure that we're fighting on behalf of those individuals for their rights. But that comes, in terms of that staff, that's a significant cost. And the current, the bill 1338 contemplates funding through the state bar's nonprofit legal service trust account, or I'm sorry, it's Legal Services Trust Fund, and that commission of the state bar. Public defender offices do not statutorily have access to those funds. So we will be forced to come up with some creative funding metric and ask to the Board of Supervisors, assuming we do staff the courts. I can't speak for Marin County's legal aid or any other legal service provider in Marin County who may staff those courts. But I am just currently operating under the assumption that we will likely staff those courts. The second concern and major concern, and I guess want to have my staff involved within these courts, is a large number of public defender clients would likely be subject to care court. So those are individuals who are involved in what's called mental health diversion. So their underlying criminal case, they're potentially being diverted out of the criminal justice system as a result of an underlying mental health condition, which substantially was a substantial ingredient to their alleged criminal conduct. As Mark will go over, we represent individuals who are in LPS conservatorship situations. So again, those are public defender clients, as well as clients who may have been experiencing homelessness, mental health issues, and are current and or past public defender clients. So individuals that we already have a relationship and can build rapport with rather quickly, I think, which goes to the third point and concern, real major concern that we have within care court. I don't want to get too deep into the nuts and bolts of the operation of care court, but essentially a petition is filed either by a first responder, behavioral health, or a family member or someone an individual resides with. And a judge reviews that petition. And if that petition makes a prima facie showing of care court participation, a hearing is set within 14 days where the respondent, my client, the individual suffering from a mental health condition, is ordered to appear. And from there, there's about a 45-day window when many decisions are being made about that individual's life, about whether or not they should be actually participating in care court, should submit to clinical evaluations, should come up with what's called a care plan, etc. So if you think about 80 individuals, the number of attorneys that would need to staff that, and on the client side, us, one, locating that individual if they are in fact unhoused, two, building rapport with those individuals who are, if they are in fact suffering from mental health conditions, which could be challenging, right? Three, our primary goal and focus in this role, actually advocating on behalf of clients and patients' rights. So do they need to be in care court? And in order to do that, we have to gather historical mental health records and prior clinical evaluations, potentially come up with our own plan for voluntary treatment, medication, and stabilization to basically exit out of care court, et cetera. And that's on a timeline, say, within 14 to basically 45 days. And based on the sheer numbers, that is breakneck. And that is something that the public defenders, we pride ourselves and being able to operate in chaos and operate not competently, but effectively and zealously in chaos. But again, we have to have the proper staffing to do so. So that's our real main concerns, and is essentially staffing and doing it right, and doing it right by the client and doing it right by the patient. I think probably everyone involved, and I don't mean any disrespect, but the real concern is that individuals will be referred to care court by family members or loved ones, and who don't, take a real strong view or real close view of what the actual care court criteria is. So having to litigate and work through, basically community referrals to care court when an individual might not necessarily meet the elements of care court in the first instance, right? Taking away from bandwidth and resources to address individual participants in care court. So that's my real quick piece on care court. Regarding forced medication and involuntary medication orders in the jail. The public defender's office, we're involved with that from the first instance, especially where an individual, we're litigating their competency to stand trial in the first instance. So, under California Penal Code 1370, there's 3 areas where a forced medication order is delivered by a court, and the public defender's office, or conflict counsel or retained counsel, is representing the client in those situations before the order is in place. I will say anecdotally, and Jamie or Todd can correct me, I do believe since the board has approved involuntary medical orders, it's only occurred twice in the jail, and they were both public defender clients. And often in instances where we being the attorneys, would actually like that to happen, not the involuntary medical order, but our client medicating and stabilizing when they are in a situation waiting for a bed at the state hospital. This time in these instances, up to, I believe it was 6 months, and really severely decompensating for lower level felonies and sitting, in deplorable conditions of their own making as a result of their mental health conditions, where, if they are voluntarily taking medications and working both with us and our staff, potentially we're either resolving the case or litigating the case, or getting them out into the community as opposed to in a jail setting. But when they are waiting for a bed at the state hospital in Napa, where there is unprecedented backlog and months on end waits, it is a pretty significant situation. So that's not to say that we are on board in every instance, but we will in fact litigate when we do not believe it is in the best interest of our clients, or we believe that there are other alternatives to an involuntary medical order. But that's done in the Superior Court. So thank you, and I look forward to answering your questions.
Thank you so much, David. That was excellent. Very clear. I really appreciate it. So now I'm going to turn this over to Mark Vanderscoff, who's our public guardian. And then after he presents his PowerPoints, which I will show in a moment, then we'll eventually get to Q&A. And so don't forget, you can put a question mark or type your whole question into the chat in preparation for that. So hang on, Mark, and I'll get your slides up.
Thank you. Good morning, everyone. While Doug's doing that, I'll introduce myself. So I am Mark Vanderscoff. I'm the public guardian conservator for Marin County. I've been with this office in many capacities, both as a deputy, as a supervisor, and now I am the public guardian. I also have a background in adult protective services and working with mentally ill adults in Buckaloo programs. Before I discuss Care Court, I do want to just back up a little bit and tell you about the function of our office, because I'm not sure that everyone understands what it is exactly we do. So if I can have the first slide, Doug. All California counties have a public guardian, public conservator. We are a mandated service. We administer conservatorship programs. There are two different types of conservatorships. The first is the LPS, also known as mental health conservatorship, that we'll be discussing today. That is reserved for individuals who are considered to be gravely disabled and unable to provide for their food, clothing, and/or shelter due to a mental illness. The other type of conservatorship is a probate conservatorship. That's generally reserved for older adults, reasons being of cognitive decline, maybe a brain injury, something that's preventing them from administering their estates effectively and managing their personal affairs. So my office can be appointed the conservator of the person or of the estate or both. If we're appointed the conservator of the person, that means we're going to be placing the person, making sure they're safe, making sure they're getting the services that they need. If we are in charge of the estate, then that means that we're administering the estate frugally for the benefit of the conservatee. So it's good for you to know that we do not receive any state funding. My office utilizes all county funds, county general funds, which means when it comes to placing someone, a conservatee, if they're an LPS conservatee, we rely on our partners, Todd, with behavioral health. If it's a probate conservatee, we need to place the person utilizing their own resources. And if they have limited resources, it's going to make my office's work difficult in placing them, just as it would for anyone else. Okay, next slide. So that's a little background. Again, I just want to briefly go through what the current process is for getting on an LPS conservatorship, because it's fairly difficult, which I think is good. LPS conservatorship does remove individual rights, and it also should be utilized as a last resort. So these are all welfare and institutions codes that you see up here on the screen. What kicks the process off is a law enforcement or a licensed mental health clinician can put someone on a 5150 hold, which is a 72-hour psychiatric observation. Generally, that takes place at our crisis stabilization unit here in Marin County. They're observed for a period of up to 72 hours. If at the end of that period of time, it seems like they're not stabilizing, then they're referred to a short-term psychiatric hospital, acute psychiatric hospital, such as Unit A, which is also at Marin General. There, they can be placed on a 5250, which is a 14-day hold, or a 5270, which gives additional days to total 30. But regardless of which hold they're on, at the end of that period of time, if their psychiatrist feels that they're gravely disabled and they're not able to provide for food, clothing, and/or shelter, then they're going to get referred to my office. My office then investigates the case. We have 30 days to write a report, which we submit to the court. We're going to be interviewing the conservatee, their friends, their family members, their psychiatric providers, and we're going to be coming up with a determination, which can be one of three things. It can be A, we feel the person does need an LPS conservatorship. B, we feel that they are not gravely disabled and do not meet the criteria and can dismiss the case. Or C, we have an option of extending the temporary conservatorship for as long as 6 months. Generally, if we're going to do that, we're doing that in hopes that they stabilize so that we don't need to institute the LPS conservatorship. If we do go to court to institute the LPS conservatorship, that's good for a period of 1 year. At the end of that period of time, we need 2 doctors' affidavits to move forward stating that the person is still gravely disabled. So this process has a lot of safeguards built in. There's a public defender assigned right from the get-go when we start getting the referral. The individual can challenge any one of these psychiatric holds, whether that be in the hospital or at the crisis unit. They can and do challenge any hold. Also, when it gets to the point of us wanting to initiate the LPS conservatorship, they have the option for a court trial or a jury trial. Also, this procedure, if someone just goes through this once, they're not going to get referred to my office. My office only gets referrals if someone has been tried in the community multiple times and they're failing and it's just not working out. So again, we are the last resort. This does keep numbers down. Right now, my office has 102 LPS conservatees. That's a fairly small number considering we have over 250,000 people in Marin. So that's the current process, and that could be affected by the care court. So if we could have the next slide. So care court, our concern is that with a wider net, like Todd said, and David, family members can refer, friends can refer. There are going to be a lot of people probably referred to the care court. Granted, there does need to be a psychiatric evaluation and a care plan put in place if they are accepted. But this means that then those individuals are going to have to abide by the care plan. They're going to need to go to the court hearings. There's a high likelihood that they may not be able to do that. So at any time during this process, as has been mentioned, the judge has the discretion to refer to my office for an investigation if the person is refusing services or not doing well. So if my office gets a number of increased referrals, that means obviously we need to investigate them. Our investigations are time sensitive, detail oriented. If we have a lot of people coming into the system that we're going to need to investigate, as David's saying with his staff, my staff would need to be increased as well by 1 or 2 positions so that we'd have enough people to investigate and do justice to the individual. Also increased referrals, that's going to increase my deputy's workload. It's going to increase the public defender's workload, who represents the conservatee, and county counsel, who represents the public guardian office. The other possible concern with the care court is new services or placements. Right now, at times there's a waiting list to get people in a board and care, particularly in Marin County. The locked facilities sometimes have waiting lists. So if we are getting an influx of people into the system, we just need to make sure that we have places to put them. And again, in terms of funding, my office at this time does not have access to funding. All right, thank you. That concludes my remarks on the care court. I see there's one question already, but I'll look forward to answering questions when we're all done. Thanks.
Okay, so Nancy Weber will be handling the questions. Thank you so much, Mark. That was really great. So before Nancy starts, I do want to thank you for that.
Thank you, everyone. We do have one question in the chat box right now, and that is, what is the appropriate path in housing for a severely mentally ill adult not able to provide for food, clothing, shelter, and who is also suffering from a neurodegenerative condition, for example, Alzheimer's disease?
Well, that would be a tough combination to handle if such a person was referred to my office and under conservatorship. Frankly, it would be difficult to find a placement that is going to be able to address both components, the mental illness and the Alzheimer's. If they're going to be conserved under the LPS Act, the primary diagnosis does have to be mental health, a mental health issue like schizophrenia, bipolar, major mental illness. If the primary diagnosis is Alzheimer's or dementia, that doesn't qualify, unfortunately, for a mental health conservatorship.
That sort of addresses what David was saying earlier, that there's a lengthy process to evaluate these people who are referred. And oftentimes, sorry, Murphy's Law. Oftentimes they might not meet the necessary guidelines, and that uses the staff resources. So David, is there a way that you can shorten the process initially from the front end?
Well, we're not, we're not involved on the actual front end, or I'd say the respondent's attorney is not involved. So a petitioner, this is either a first responder, behavioral health, family member, or someone that resides with the individual. They, file a petition with the Superior Court, and the care criteria is the person's 18 years old. They have a severe mental health disorder, which is not clinically stabilized, and one of the following: that individual cannot survive without supervision, and their condition is deteriorating, or they need services to relapse. So kind of outside of those elements, they are not a suitable candidate for care court in the first instance, which we're talking about resources, we're talking about bandwidth, but on the flip side, I do understand that we are talking about an individual's loved one. So I don't want to be too flippant and say, we're concerned about our resources, our timing, our staff, and being able to respond to individuals who are participating in care court. On the flip side, there are community members who are suffering, right, and family members who are dealing with the ancillary issues that come with mental health or degenerative disorders as well. So just to say that. Yeah.
Todd, you were nodding your head. Did you have something to add?
So yeah, first of all, just to echo what David just said, that these are people. They're not just kind of cases or an abstract thing out there. These are people who in many cases are really suffering. And so it's our goal to provide as timely as possible of services. So for the behavioral health side, when somebody gets referred, we're going to have kind of 3 initial pieces, and it's going to be challenging to speed up that process. So there's an initial case review to determine sort of generally if somebody's going to meet the legal criteria. And then there's going to be a comprehensive evaluation of whether they meet that criteria. And if somebody does, then there is a development of a care plan. So each one of those pieces is going to take some time. And also just to add to the mix that this program is really focused on people who are unhoused or experiencing homelessness. So it's not necessarily that we can find people immediately when it's time to do these evaluations. So there is going to be some legwork, some outreach, some engagement work that is needed in order to bring the person into the office to do these kinds of evaluations. So we do have some concern about the timeline and about the resources that are needed to get this process moving.
Thank you. We have a question here. Will the recently expanded Medi-Cal case management program have any role in the care courts?
Maybe, if I can say that, it's Cal AIM is a new change in how Medi-Cal is operating. It's a phased implementation process starting last year and moving all the way through 2027. And there are some new case management options for folks who do have Medi-Cal called enhanced case management and then community supports. So we do think that will have sort of an ancillary role in supporting people who are in care court and also potentially preventing people from getting into care court. So that's how I would see the nexus there.
Thank you. This is from a a mother. As a mother of a mentally ill inmate who is transferred to Napa after 6 months in the Marin County Jail, it's frustrating because what my son needs is wraparound services and not simple medication to make him lucid enough to stand trial. He was not compliant with meds before his crime while in jail, and the likelihood he will be compliant when released is not high. Jamie, would you like to address that?
Yeah, so I could tell you, we have a reentry team in our jail facility, combined of our own deputies, probation, health and human services, social worker. Their primary function is to reduce the recidivism rate at the Marin County Jail. So upon release of an individual, usually 60 days or more, they'll start working with that individual on what needs he or she might need upon their release back into the community. So that is one outreach program that we do have at the Marin County Jail for those individuals. And it could be anywhere from housing to job searching to mental health needs. So it's whatever that individual needs.
Nancy, I've got a question.
Yes.
I think this is really for Todd and David, which is I'm unclear on the process for getting people into the system, into the beginning channel here. So if, for instance, a parent knows where their son is and he's severely mentally ill and he's living under a bridge somewhere in Marin, how do you get him to talk to mental health people to make these initial evaluations? And then how do you get him in front of the judge and so on? And I mean, presumably this person is pretty non-compliant, or he'd already be getting care. His parent wants him to have care, but he's not doing it. So how do you, I mean, would a first responder, take him somewhere, or would he have to first go to through a 5150? And then how does he move from there, from the 5150 into appearing in the civil court in front of a judge?
So I think some of this is to be determined. We're 2 years out from the launch of this program, or at least the required launch of this program. And so that initial first step is one that has yet to be determined, but the first step is designed to be an actual affidavit to the court. So somebody will petition the court that there is an individual in the community that needs this level of care. So the court, as the first touch, would then refer out to my department, to Behavioral Health and Recovery Services, for that initial screening and that evaluation. And just as a side comment, we're here talking a lot about Care Court. There's been a tremendous amount of community interest in Care Court. We're trying to be very mindful of our planning and making sure that we're having thoughtful conversations about what this will look like. But we also don't want to over plan at this point. There are 7 counties that are piloting this starting in 2023. And we're really hoping to learn from their experience so that we can kind of have the best program possible, the most compassionate program here. So some of the details we don't yet have worked out.
Thank you.
Glen, Riverside, San Francisco. Sorry, I'm jumping ahead. There's a question in the chat about the initial counties. So it's Glen, Orange, Riverside, San Diego, Stanislaus, Tuolumne, and San Francisco.
Did you do that from memory?
I tried. I had 4.
This is a question. I know a young man who has been homeless in Marin County since he was 18. He is now 38. He needs medication for his mental health condition. He and his dog live in his car. He lost his housing at Homeward Bound because he attacked someone who stole his bike, but the person convinced him that he was at fault. So I guess he is a moderate case. Will Care Court be a resource for him?
I mean, Todd, you can jump in as well. To me, this sounds like this individual is not, although he may have a mental health condition, it's not, he sounds clinically stabilized, right? And he's surviving without supervision, and his condition is not deteriorating at this point. And again, these are the situations where this is an individual who clearly is not, who has needs, but in terms of the elements or the criteria for entry into care court, and that prima facie showing, or even later on under the clear and convincing standard, to me, and Todd, please jump in, I don't believe this individual would be the care court participant, or appropriately a care court participant.
Yeah, I would agree without any additional context. It's hard to know, but we are going to be very much kind of within the confines of the statute, and that's the basis of the evaluation. As an analog, we do have assisted outpatient treatment in Marin County. That's also known as Laura's Law. And so I see care court as sort of it's built upon Laura's Law in that it is a court-ordered outpatient treatment model. But similarly in AOT, the legal criteria are very specified, and in many cases, folks that were referred are actually not eligible because the criteria are so specific.
Thank you. What oversight is planned for protecting individual rights, safety, and equity? That's open to the panel.
Can you repeat the question? I'm sorry.
What oversight is planned for protecting individual rights, safety, and equity?
I think that largely falls on the public defender's office, and really advocating and ensuring that clients who don't belong in care court or should not be subjected to care court are safety valves in the first instance, whether or not that's the initial 14-day hearing, the follow-up 10-day hearing when there's, or excuse me, the clinical evaluation hearing 30 days on, or the final care plan 45 days on. So it's at every turn. Our attorneys and staff should be really vigilant, and like I said, providing a high quality, zealous legal representation of these individuals.
Thank you. And this is a two-part question. How many people in Marin receive FSP services, and might those services preclude them from participation in care court? And then two, this is probably a part of the oversight question. Is there any reason not to have ACLU weigh in on involuntary medication protocols?
So to the first part of the question, FSP is full service partnership. So that's our highest level of behavioral health care. I don't know the exact number, but I would estimate it somewhere around between 400 and 500 people currently receive FSP level services per year. That would not necessarily preclude them from participation in care court. However, the statute does require that people are not voluntarily engaging in treatment. And so there is going to be a little bit of gray area about what does that mean to voluntarily engage in treatment. Does taking medications but not participating in treatment groups count, for example, as not voluntarily engaging, or does it have to be no engagement in treatment, period? I'm not sure at this point in time. As far as we have not had the ACLU weigh in on the involuntary medications protocols, we do work with the patient's rights advocate. We have shared those protocols with them and have had some discussions with them about that process.
Thank you. And then I think much of the conversation revolved around funding and how it's very limited. I think the first payment from the state was $250,000 to Marin County, and that's only for the planning and implementation. When are you when are the allotment? When is your next allotment, and do you know what size what amount of money you'll be receiving?
We're not actually anticipating any additional money from the state, at least not care court dedicated funding. It's possible there will be some cleanup legislation next summer that will include an ongoing funding source. We have been advocating that through our advocacy organizations. So really, it's looking at existing funding sources to create this program essentially from scratch. So on the behavioral health side, we're looking at our Mental Health Services Act funding as a potential source to provide the treatment services.
Mhm.
But that is subject to a public 3-year planning process, which is happening right now. So we can't do anything without the public's say-so in MHSA.
And then Mark, how about your shortfall? You received no state funding.
Right, we received no state funding. There is an association of public guardians, conservators that is statewide, and we did go to the state this last fiscal year and ask for 200 million for our offices just to help us with staffing and that type of thing. That hasn't worked out for us yet in terms of getting funding, but we're going to continue to go to the state, I'm sure, next year and ask for funding as well. But yes, otherwise, all of our money comes from the Marin County General Fund. We do have a few programs in-house that generate income, but it's not significant.
We should
And-
probably mention that the supervisors agreed to $500,000 this year for this initial setup period. And who knows how much money going forward.
And then Jamie, you have mental health, I'm sure, included in your budget. Is there a way that you could be moving monies around?
That actually would be budgeted under Health and Human Services.
Only, okay. Mhm. Thank you.
Well, if there's no more questions, I think we're really running really close to our schedule here. So anybody got another question? Oh, poor David. I'm so thank you so much for coming, David. I know you're not feeling well. So yes, thank you to all of our speakers, and thank you the audience for coming. And I just want to let everybody know that we are planning to have more meetings on this topic as things proceed, both in this county and other counties. We'll keep you informed, and we'll let you know when we've got our next meeting panel discussion coming up. So thanks a whole lot. See you next time.